So in the very same year that U.S. v. Virginia is handed down, the Supreme Court hands down another case that deals with gender, but also deals with federalism, and proves to be a much more controversial case than U.S. v. Virginia, though it comes out of the state of Virginia as well. This is the 5-4 decision authored by Chief Justice Rehnquist. You may have heard about this case, though for many of you, I'm presuming you were born after it takes place. But this is a case regards an alleged rape by the football players at Virginia Tech. In this case, the woman in question alleges that after meeting two men from the football team at a dorm that they used force to repeatedly rape her, and that she alleges that one of the players afterwards boasted of these and bragged in a very similar fashion to what one would expect. Now, no criminal charges were brought against either of these football players because the local district attorney determined that there was insufficient evidence since there were no witnesses of the sexual assault. The woman, of course, files a complaint with the university. The school conducts a hearing. One of the football players is found guilty of sexual assault and suspended for 2 semesters. The hearing also determined that the other football player, there was insufficient evidence against him. The player that was found guilty brought a court challenge to the school's finding. Virginia Tech held another hearing because the school believed it was in error to bring a hearing against the football player. After the second hearing was handled, the university handed down an identical 2-semester suspension, but the description of the offense was entirely changed. The description of the offense was a sexual assault, was changed to using abusive language. There was absolutely no explanation given for why sexual assault changed to using abusive language. So essentially he was convicted for bragging about sexual assault, but not the actual sexual assault itself. Morrison Appeals, the second conviction and suspension through the university's administrative system, where the university set aside its punishment, stating that it was excessive when compared to punishments for similar incidents. So in essence, because he was ultimately found guilty of using abusive language, his 2-semester suspension was out of step with the conviction for that charge, and therefore the university puts aside his conviction because it was out of step with similar incidences, totally sort of shrugging away from the fact that the sexual assault had occurred at all. So after learning from a newspaper that Morrison would be returning to Virginia Tech the following semester, the woman in question drops out of the university. Even if none of the claims in this case are true, the issue that occurs here has happened in an uncalculable number of rape cases on college campuses. Women are triple victims in cases like this. First, they are assaulted by the attack themselves, the sexual attack. Second, they are assaulted by the system. In this case, the woman in question was assaulted twice by the system. So usually at this point, and understandably so, victims of rape are so downtrodden that they give up. The woman in question in this case simply did not. So even after the police and the university provide her no service, the woman decides to press her case, believing that she would find justice at some point somewhere. And in fact, there does exist a venue, or at this time there existed a venue, for issues such as this, because Congress in 1994 passed the Violence Against Women Act, which I will just call for the purposes of the rest of this VAWA, What it was designed to do, among many things, was to give women another potential avenue for justice when traditional avenues had been shut down. In particular, one part of VAWA provided that all persons within the United States shall have the right to be free from crimes of violence motivated by gender. To enforce that portion of the law, Congress provided that anyone who commits a crime of violence motivated by gender shall be liable to the party injured in an action for the recovery of damages and such other relief as a federal court may deem appropriate. So basically, sexual violence is generally not a federal crime. So federal courts generally don't have jurisdiction over these issues. But what Congress did in VAWA was to give federal courts civil jurisdiction, so the ability to sue their attacker, not necessarily attempt to prosecute them for a crime, but to sue their attacker for damages and gain monetary reward. So it opens up the federal judiciary to victims of sexual violence to receive a monetary award, to receive recuperation in a civil case as opposed to a criminal case. So the issue in this case, and the reason I go through all of that, is the issue in this case deals with the constitutionality of VAWA, as which it gives women the ability to sue in federal court system for crimes based upon gender. Congress based its authority to pass said law on the section of the 14th Amendment which gives Congress the power to enforce the amendment by appropriate means, otherwise known as the Enforcement Clause. And they also granted power they claimed power based upon the Commerce Clause. The Supreme Court in this case, in a 5-4 decision, decides that the law was unconstitutional as it went beyond Congress's power to enact a law under either of those provisions. Now, this is fairly shocking. Not the 14th Amendment part, which if you recall, the 14th Amendment has largely been gutted in terms of Congress being able to enforce through things like the slaughterhouse cases and the civil rights cases. But the Commerce Clause, that's Congress's multi-tool. They can use the Commerce Clause to get to anything. Remember Heart of Atlanta Motel. The Commerce Clause can get to something that substantially affects interstate commerce. What the court argues is that gender-motivated crimes of violence are not in any sense of the phrase economic activity. So the court says that no sexually based violence of any sort is economic activity. There are a number of sexually based crimes that one could consider economic activity, and I need only point you to federal law itself, such as the Mann Act, which criminalizes an individual taking a woman across state lines for sexual or deviant purposes. It is the very definition of a gender-motivated crime that is economic activity. But the court disregards this. So the court dismisses the interstate commerce claim, citing United States via Lopez, which is a case that the Supreme Court declares unconstitutional, a criminal statute that banned guns in school zones. So within sort of 4 years, the Supreme Court has sort of tried to roll back interstate commerce as a tool for Congress to sort of reach into the states. So what about the 14th Amendment argument? The Supreme Court cites the civil rights cases and simply says that that Congress can't really do it. And so it's unfortunate, and the court, Chief Justice Rehnquist in the majority, cites that, well, it's unfortunate that federal government can't do anything. What he says in conclusion seems so out of step with common decency, but here we are. If the allegations are true, no civilized system of justice would have failed to provide her a remedy for the conduct of Respondent Morrison. But under our federal system, that remedy must be provided by the Commonwealth of Virginia and not by the United States. So I'm not sure if he's calling the state of Virginia uncivilized. He wouldn't be the first. But he does articulate a legal-based reason why the United States cannot provide remedy for this issue. The 4 judges in dissent are not at all pleased. The primary dissenting opinion is from Justice Souter, and all 4 other dissenters join it, asserting that the federal law should absolutely not be unconstitutional, as it does not run afoul with the Commerce Clause or the 14th Amendment. And they turn to data. The data they rely on cites that 3 of 4 women in the United States will be victims of gender-based violence at some point in their lives. They use a long list to cite the extent of gender-based violence. They demonstrate how gender-based violence has an effect on interstate commerce. The interstate commerce effect that they discussed is based upon women strongly being deterred from traveling during certain nights of the day, refraining from engaging in certain types of business, and also, and I think this is probably the most clear connection to economic interests, women face increased medical costs because of sexual assaults. That seems to have a very direct connection with economic activity. So for them, they make the rough analogy, analogy between gender-based violence in the 90s to race-based violence in the 1960s, which Heart of Atlanta Mattel is the perfect example of regulating interstate commerce. And they strongly disagree with the vein in which the court has gone, especially with regard to interstate commerce, but more particularly in this specific area, where the court negates a portion of the Violence Against Women Act that sought to give women the authority to access federal courts for civil damages after they had been denied recompense within their own states. But that part of VAWA is declared unconstitutional, a very sharply divided court, and also a very unpopular decision at the time.